Yes, welcome to live show today. My name is Sohail Ahmed. I'm a solicitor at SWF Solicitor. Today I'll give you a couple of update. Recently, the Home Office pronounced, as well as primarily there are some case law, which is there is some decision came regarding whether skilled worker who working voluntarily in any shop where the Home Office encountered them and they're saying that I'm non-paid voluntary working. This is one case. Another relevant case is where the someone's sponsor license been cancelled. He has not received 60 days later, and they later he applied for leave to remain, and his visa is cancelled irrespective of whether 60 daes later Home Office need to give or not. Another also I'll speak about again some EU settlement scheme, and also those who apply for further leave to remain but you don't have share good not working, or you don't have immigration status which is not shown online, how you can get some information about the immigration status. So let me start with skilled worker. Now this is a common scenario when immigration when someone come on a skilled worker visa or student visa and you are working somewhere, especially for care worker and skilled worker visa. Majority of the care worker, they don't have job, majority and many skilled worker, they don't have work. They are not working for their employer rather than working different places, cash hands job. And if the Home Office come, you prepare to say that I'm working voluntarily and I'm not being paid. Now the question is whether you are allowed to work voluntarily while you on a skilled worker visa. This matter basically explain and a judgment given in the case of R. Andrew versus Secretary of State, Home Department. In this case, what the court refer is, the High Court refer the definition of voluntary work means the work which is unpaid, and you must work in a voluntarily organization, charity, voluntary organization, an associate fundraising body, or a statutory body which is not entitled to any monetary payment. So if you are a skilled worker, you must work for your employer. If you are a care worker, you must work for your employer, means the employer who sponsor you, or additional 20-hour job in but not every job, which is a occupational job, a salary listed job. But you can't work in a grocery shop or a restaurant, and if the Home Office come and encounter you and you will say that I'm working voluntarily to get for work experience. No, if you work voluntarily, you need to work in a organization like charity, any government, any associated fundraising body or a statutory body which is mainly carry out the charitable work. So this is one of the important, because many people who work in different places and presuming that if the Home Office come and encounter me, I'll say I'm working voluntarily. So this is the one decision. The other court decision also is very important for the care worker and the skilled worker visa holder, and the outcome is many people came in the UK as a care worker or skilled worker visa, and their sponsor license has been cancelled, suspend working. The question is whether your visa is still valid despite the sponsor license has been cancelled. And I told in previously in different live session and questionnaire that in my opinion, firstly by operation of law, your visa is also suspend, cancel or revoke. Home Office not under an obligation that they must write it to you as 60 days later. In case if you fail to write a letter, this doesn't mean that your visa is valid, and that question now formalized by the court And in the Court of Appeal, what the court said, this basically a skilled worker visa who has not received 60 days letter that their sponsor license has been cancelled, on that he has no knowledge, and later she subsequently applied for a leave to remain, claiming that my visa is still valid despite the sponsor license has been cancelled, because Home Office hasn't write me that they revoke my visa or offer me 60 days time. Therefore, it's procedurally unfair. The court said no, this is not procedurally. Court refer basically different case and say in Patan itself, example were given cases where fairness would not require an applicant to be informed of revocation. The Home Office doesn't require to the applicant that their visa has been revoked, and this is not trigger the unfairness of Home Office part. So what I understand from this judgment, if your license, your employer license cancelled, curtail, revoke, suspend, Home Office doesn't require, or if the Home Office doesn't write a revocation letter to you or offer you 60 days to switch to another visa, that will not make the Home Office decision to curtail your visa unfair. It will not make it unfair. So if you don't receive 60 days letter, don't wait that let the Home Office write me a 60 days letter, then I'll take a step. This will be a mistake, because if the Home Office later revoke your visa, you will not be able to do anything. You can't challenge Home Office because this is not an unfair. So this is important case law, which is a decision from the Court of Appeal. And then second one, the second question or update I will give you, all of we know that you need to make the application 28 days before your current visa expire. Within 28 days, so like if your visa expire 28 days later, you can apply anytime between this period, or 14 days, because this is a common mistake many people do, that within 14 days of your visa expire. This 14 days is not very straightforward, that this is not a automatic right that I can make an application within 14 days not to become an overstay. The point is that you can make an application within 14 days if there was a good reason beyond your control that you cannot make the application on time. Then you can make an application within 14 days after your visa expire, and still you will not be an overstay. But without any good reason, without any without anything which is not within your control, you just trying to take an advantage of law. In that case, Home Office may come a conclusion that your visa has expired. You haven't made online application. So this is also an important things to discuss today. Viewers, this is a live program. If you have any question, feel free to call to the number appear at the bottom of the screen, which is 020 37879200. Now the other update also, EU settlement scheme. Now EU settlement scheme, this was a quite correct decision which was previously Home Office also published, and their decision that those who will be eligible for settled status under the EU settlement scheme, the holder of pre-settled status, they can they will automatically receive settled status. They don't need to do anything. They don't need to apply for settled status. But there is some tricky point which I would like to also mention. Now, the 5 years, those who will complete it 5 years, and the Home Office will find in their system that they was in the UK, they are working from HMRC record, from NI National Insurance Contribution record, from benefit record, those who claiming benefit. For them, basis specifically, Home Office will give them automatic settled status under EU settlement scheme. However, those who is not working, those who was absent in the UK, they will not get automatic settled status. So you need to revisit, speak to a lawyer whether you are entitled to settled status, because this is very important to understand that whether you were eligible for settled status. You got the pre-settled status, it doesn't guarantee that you'll get the settled status, even though if you apply. You need to satisfy the requirement, eligibility requirement. If you absent for long period of time in the UK, that is a concern, matter of concern, and you need to get advice about it. The other thing is when 5 years counting. Now, from my position, normally I count the 5 years start from the point the EU nationals or the non-EU nationals enter UK, from that day under the family permit. But however, and then he applied on time for pre-settled status, and maybe after 6 months or 3 months later, you or he got pre-settled status. However, the Home Office position for automatic settled status, they are counting basically from the day they granted pre-settled status. From that day they count 5 years. So this is also an issue which some of you can make the application if you want to get if you don't think that it will delay your pre-settled status. And for settled, you don't need to satisfy, it's also called indefinite leave to remain. You don't need which is English language certificate in B1 life in the UK. So this is the good things. However, if you have a plan to apply for settled status, naturalization, to become a British citizen, then of course you need to have the B1 and English language test. So once you get your ILR, prepare to have the B1 English language certificate and life in the UK test. Also, you need, before you make the application for naturalization, have a look whether you satisfy the residential requirement, because under EU settlement scheme, the residential requirement, you don't need to satisfy the that last 1 year you was not absent 90 days, and last 5 years you wasn't absent 450 days. This is not a requirement to get the ILR under EU settlement scheme. However, when you apply for naturalization, British citizenship, satisfy the residential requirement. So this is also important to know, that if you are absent for quite long period of time, you may have the settled status ILR under EU settlement scheme, but you may not get the which called naturalization. The final thing I would like to address, many people applying and or had applied or will apply for e-visa, and when you log in on Home Office system, it doesn't show the correct visa or correct leave to remain when it will expire, or your surname or your name is not correct. For this situation, you can contact with the Home Office. And also regarding your immigration status, especially those whose visa has been expired, you apply for leave to remain, or you apply for fee waiver application, or you going to or some of you don't know what is your immigration status. Some of you may lost your ID. I'm dealing one case where British ILR holder, which is nearly 20 years in this UK, and he lost his ID, everything. He doesn't know what his immigration status is. I can't apply for him for e-visa because he doesn't have ID or travel document. He doesn't have any form of any document. So in that situation, what you can do, we have subject access request information, what you can apply, get this. But other than most easiest way, which you don't need to go to a solicitor as a lay person, you just complete this form, name, date of birth, your information regarding address, and you can complete this form and then send it to the Home Office. If you have any document, a copy, you can attach it, and then within 10 days, normally 2 weeks, Home Office come back with your immigration status. Specifically, say for example, if someone leave to remain has expired and you applied for an extension or fee waiver, now your share code is not working. Home Office system doesn't show you the share code, so your employer is not offering any more work, maybe benefit issues, the other problem. So what you can do in that types of situation, you can complete this form, get a response from the Home Office and give it to your employer. Of course, if you have a lawyer can write a letter under section 3C leave. Alternatively, your employer can also complete this form and send it to the Home Office by email. Very simple form, just a basic information about your name, date of birth, and you can send it to the Home Office, an email called ukvi.ic@homeoffice.gov.uk, and you can send it there, and you can post it as well, and then the Home Office will come back. If you need this, you can Google, ask the Home Office to check your immigration status is correct. If you Google it, the form will appear on the screen, and then you can complete it on computer or print it, write it by hand, and you can send it off for the Home Office. So this is today all about update. I hope might be some relevant all of you, some of you. By the way, if you need any help regarding immigration, family, commercial leaves, property, and other practice area, please feel free to contact me. My name is Sohail Ahmed. I'm a solicitor, principal solicitor at SWS Solicitor. We have office in Milton Keynes and also in London. We also provide services online via Zoom meeting. So if you need any assistance, please feel free to call to our office line appeared top of the screen, which is 020-8090-4780, and make an appointment. This is all for today, and thank you very much who watch, like and share this video on your screen. Thank you very much.